Judge, this is my case. I think Greg has this case as well. Greg communicated an offer to me. I've declined that offer. I've given Greg a global offer to resolve all his pending cases, and I haven't heard back from Greg on that.
Yeah, I went by and talked with him this morning about it and conveyed that to him. It was, as the offer stands right now, Mr. Hicks wasn't interested in taking that. I'll try to come back with something else and see if we can resolve it. And if not, then we're dealing with 4 indictments here, so it's quite a few charges and all to try to wrap up. But if we can, we can keep trying it and see if we can come up with a resolution or not on all 4 of them.
I mean, another pretrial conference is not going to hurt anybody.
You want to do, I mean, you all tell me, when do you want to do it?
I'll leave that to you, Greg.
Okay, we're getting quite a few stacks up on the 23rd or whatever, 22nd, 23rd.
Yeah.
We can go a week after that, Judge.
All right, that'll work. February being a short month and all, the week after the 22nd will be March 1st. So we'll put these 4 cases on March 1st, the afternoon docket, okay? All right, see you then.
Excuse me, Mr. Alexander, is there any way we can work on some kind of bond issue? I've settled up all my other cases on my misdemeanors, and maybe you can let me go to U-turn or something. Been here over 90 days.
Gardner, you got anything you want to say? Oh, you're on mute.
We have 4 felony cases pending against Mr. Hicks. I mean, we can't get anywhere before another one pops up. So I think the bond is appropriate. I'm trying to make an effort to resolve the cases. I think Greg is as well, but we haven't gotten there yet.
Yeah, I mean, the thing is, you know, here we're looking at, I'm trying to see, 3 of these 4 cases involve fleeing or evading. One's a Class C trafficking felony. One's a felon in possession of a handgun and a theft of a handgun charge. We already had a bond, you know, I let you out on bond and then ended up having to have a hearing and revoking your bond. You know, right now, I think things are appropriate where they are. I think that Mr. Hicks, you know, I think you're a flight risk.
I've never left home. Even Officer Tyler Maxey will tell you, anytime you want to find me, I'm right at home. I haven't never ran, but I understand what you're saying. What is my bond?
Well, we had a bond revocation hearing the last thing we did, so your bond got revoked.
Yeah, you said we would reconsider it later and maybe go to rehab again. You said I've been asking for it the last 3 times, and you told me maybe later on. They've agreed to accept me back at ARC. I mean, I really need to go. I mean, all my charges have been drug related. I haven't never sold drugs before in my life. They got me with a trafficking. People are saying that I've brought them, and that's not true.
Okay. Well, listen, I mean, I didn't say you were guilty of that. I said that's what your charges were. I mean, I don't know the facts of the case, you know.
I mean, I got in trouble when I got out. I mean, I've just served that time out for 90 days. I served it out. I paid for that. Maybe you can let me go to U-turn if I failed a drug test or anything like that. I mean, I don't ever go anywhere.
I understand. Listen, at this time, I'm not gonna change that, okay?
Yep.
All right, thank you. John Johnson? Mr. Bell, he might be doing. Oh, I thought,
You're welcome. Have a good day. Judge, I have Mr. Johnson.
yeah,
Judge, we have these cases set for trial July 20th through the 23rd. I think this has been scheduled as the final pretrial conference. We don't have another one between now and that date.
okay.
And, you know, and I just like to keep those trial dates on so we can move forward with it.
I didn't hear you.
I said I would just like to leave the trial dates on for that date, Your Honor. And, you know, and try to not put him off any longer. He's been in jail a long time on these charges.
Sure. Well, I mean, I don't have any problem leaving them on,
Yes, sir.
okay?
Yes, sir.
You all know how to get something on the docket if you want it.
Yes, sir.
All right.
Hey, can I run something by the judge?
Yeah.
Judge, I talked to you last time about my vision, and you told me you said you needed more information from my doctor, and they faxed the paper saying I needed to learn Braille, and there was a couple more things in there that he said I needed, and I was just wondering if you got that.
Mr. Johnson, I did get something. I hadn't gotten anything recently. I don't know when, I mean, it was some time ago, but I can't recall when exactly that it was. You just went to the doctor last week, didn't you?
Yes, and he was supposed to fax something else to you.
Yeah, no, I haven't gotten anything that recently.
I wanted to know, because my vision is getting worse. It's done declined a lot since I've been locked up. And I wanted to, it was a school for blind. They was trying to get me in some program to try to learn Braille before my vision goes all the way out.
Well, if they'll send me, you know, some information on that, I'll take a look at it. I haven't received anything. It was way back in, you know, I don't want to make up a day, but it was like before Thanksgiving was the last time I got anything. And I think you've been to the doctor at least twice since then.
Mm-hmm.
So if they'll send me some updated information, I'll be happy to take a look at it and see if I can do anything.
Your Honor, I would just ask if that were the case, if the Commonwealth could be heard once you receive that information, because I think we've stated, you know, the reasons why we oppose any bond on Mr. Johnson. He has, I think, 4 pending cases right now. Most of them are Class B felonies with persistent felony offender charges. So if that does come to you, I'd like to be heard on it.
Yeah, if I get anything, what I'll do is just either put it on the docket or contact you all and tell you what I've got and you know, see if you all want to agree to put it on the docket or whatever the case may be.
Okay, thank you.
Put it back on. Yeah. Okay.
John, if they would send that to my office, I don't care to forward it on to the judge or whatever, if you want to do it that way.
Yeah. However it gets in, it's fine.
Well, John,
They've communicated directly with my office on appointments and things like that from,
Yeah.
not every time, but sometimes. So they know my number. Okay.
yes.
All right.
Thank you, Judge.
Done.
He's on here right now. No, he's on the Zoom. He's the one that jumped in there and said, hey, I had to go. Yeah.
And Bonnie didn't know.
Yeah.
She said, "No."
All right.
He must have got us.
Jonathan Kirk. I think he said he joined the district court meeting. District court people gave him the trial, but I don't know what it is. They said it was in July. So there's just no change on him.
Judge, Mr. Spears and I were talking earlier about Mr. Kirk's case. He's got 2 other felony cases they brought to my attention that they're looking to try to resolve. They made me an offer that I've rejected, and I've made a possible counter. Josh, what date did we agree to put it off to?
I think the 22nd.
That's right. Judge, we can put it on the 22nd. I'll have to talk to the victims, and I've already proposed to them a possible resolution. We might have an agreement by then.
And Judge, for the record, Mr. Kirk has asked me to ask you to reconsider reinstating his bond. But I'll leave that up to you, given the closeness of the time for his next pretrial. I'll deference to you on that.
Understand. Yeah, I mean, you know, the circumstances that we have aren't really a whole lot different than they were last Monday when we discussed it. So at least for the time being, I'm going to leave the bond like it is.
Okay.
All right. Thank you.
Thank you.
Mr. Ritter. All right.
Judge, Mr. Berry and I have talked about this, and I've made an offer. Greg, I don't know if you have anything to add or if you've talked to Mr. Ritter. You're on mute, Greg.
Yes, I did talk with Quinn about it, and we don't have an agreement at this point. And I also don't have a counter offer at this point, or counter to your counter, I guess, at this point. I believe there was Quinn was evaluated, I think, by Dr. Sibley back before I got in the case. I guess it's when Tyler was representing him. And I think there appears to have been an order regarding that. So I guess there's already been a hearing on the competency.
Correct.
Okay. It appears from the report that I saw from KCPC that there may be a question about criminal responsibility. So I would like to see if I can talk with Dr. Sibley about this issue. And if he thinks I should have him seen by somebody else or whatever. I guess the point I'm getting at, I don't think I'm really ready at this point to say that he could enter a guilty plea based on based on things that I believe the officer said that Mr. Ritter was saying at the time, that there could be a real question about whether or not criminal responsibility applies here or not. If we could put Quinn's case off or cases off for about another 3 weeks, I'll try to talk with Dr. Sibley in that meantime and see what he can tell me about it, about his opinion. I just don't think at this point I'd be ready to tell Quinn to enter a plea until I know more about that criminal responsibility issue.
Yeah, I understand. It appears, I'm trying to go back. We had the hearing is probably 2 months ago at this point. So a lot of things have occurred since then, but it appears that the concerns were less about competency and more about responsibility, at least if not in all the cases, at least in one of the cases. I don't remember all the details, but that's certainly something that should be investigated. So I'm happy to defer to that time frame that you suggest there, which is 3 weeks. That'd put us on March 1st.
And Judge, I wanted to also say, just for the record, because I know eventually there's going to be another request for a bond modification. The case has been going on for a while, but I had talked with Tyler a lot about this case. And then they had chosen to wait to see if we were going to get an indictment on the other 2 cases for a total of 3. So we could have resolved that all the way back then, but they chose to wait, which is fine. But that's why this case has kind of dragged on for a little bit. Of course, Tyler leaving too, I guess, and made it drag on even further. So, but that's why we're at where we're at right now.
Yeah, I understand. Well, let's give it 3 weeks and see what happens. And then Mr. Berry will talk about whatever we need to talk about at that point. Okay?
Okay, Judge.
All right.
What's that date, Judge?
March 1.
Okay.
Bruce Snyder.
Judge, I have sent Josh paperwork. I think we have an agreement in this case. He needs to get that signed by his client. Are you proposing putting it on tomorrow, Josh?
Yeah, I should be able to get to the jail either first thing in the morning or this afternoon to get him to sign the paperwork, and we can have it on the 1:30. He should be able to plead on the 1:30 docket tomorrow if that's suitable for the court.
Fine with me.
Okay.
Judge, did you mean to skip over Misty Nance?
No.
Okay, we have an agreement on that one. If you want to-
Okay.
I sent an email.
I got it. There was just a line drawn through her name.
Oh, okay.
I don't know if I did it or somebody else did it, probably me, but I didn't. But I also just got your email earlier today with the plea document in it. So
Okay.
I don't know what happened. So anyhow, we'll call Misty Nance next. Snyder, I guess, can just stay up here. That file, Hello, Miss Nance.
Hello, today. How are you today?
I'm doing okay. How are you?
I'm all right.
I have a question for you.
Yes, sir.
Will you raise your right hand? Do you swear to tell me the truth, so help you God?
Yes, sir.
All right. Good deal. I'm going to show you a document here that's called a motion to enter a guilty plea. Do you feel like you've seen that before?
Yes, sir.
Okay. Got a signature on the back. Is that your signature?
Yes, sir.
Did you read over it before you signed it?
I did.
All right. Do you feel like you understood it?
Yeah, I think so.
All right. Did you get time to talk to your attorney about it?
Yeah, I believe so. We went over it.
All right. Is there anything that you didn't get to ask him or that you maybe have thought of since then that you want to ask him?
Just my outdate, sir.
Okay. All right. We'll have to
That's
talk
all.
about that. Yeah, we'll have to talk about that later.
Okay.
This is the Commonwealth's offer. Does that
Yes,
look familiar to you?
Yeah,
All right. And again, it's got a signature on the back. Is that you?
yes, sir. Yes, sir.
So let me ask you, if you read over that before you signed it.
Yeah,
All right. And the same thing, do you feel like you understood it?
yeah, yes, sir.
Did you have time to ask questions of your lawyer if you needed to?
Yeah,
All right. All right. Ms. Nance, these documents together strongly suggest that you've reached an agreement and you plan to enter a guilty plea today. Is that correct?
yes, sir.
Do you understand that nobody, including myself, nobody can make you enter a guilty plea? That has to be something that you decide to do on your own volition. Is that right?
Yes, sir.
Do you feel like you're being forced by me or anybody else to enter this agreement today?
No, sir.
Very good. Ms. Nance, do you understand that if you plead guilty, you waive the following rights? You waive the right not to incriminate yourself, the right to a jury trial where the Commonwealth has the burden to prove guilt beyond a reasonable doubt, the right to confront and cross-examine witnesses, the right to put evidence on in your own defense, and the right to appeal.
Yes, sir. I
Okay.
understand.
Okay. Now, do you feel like your judgment is impaired for any reason?
No, sir.
You feel like you're under the influence of anything that, to where you can't exercise, your decision-making capacity?
No, sir.
Very good. So looking at this offer from the Commonwealth, I'm going to talk to you about what I believe that it says, and we need to make sure that we both think it says the same thing, okay? All right. Count one, trafficking in a controlled substance, first degree, more than 2 grams, that's a first offense. Under the penal code, under the Controlled Substances Act, that's a Class C felony. The Commonwealth recommends on a guilty plea, a sentence of 5 years to that count. Count two, possession of a controlled substance, second degree. That is a Class A misdemeanor. On a plea of guilty, the Commonwealth recommends a sentence of 12 months. Count three is drug paraphernalia, another Class A misdemeanor. On a plea of guilty, the Commonwealth recommends 12 months. The 12 months in count 2 and 3 run concurrently with the 5 years for a total of 5 years from the Commonwealth, recommendation from the Commonwealth. There was some cash seized at the time of the arrest, which would be forfeited due to the charge. The Commonwealth does not oppose probation under supervision of probation and parole for a period of 5 years after service of a 120-day alternative sentence that would begin back when you got arrested on the case. So in other words, you would get credit for your pre-sentence custody that you've done, but I don't think anybody is telling me that you've already done 120 days. They're just telling me that you don't object. They don't object to you getting credit for however many days it is. And sometimes we just have to get the calendar out and count them up, okay?
Okay.
A condition of your probation would be that you get a substance abuse assessment and that you comply with the recommendations, if any, that come out of that assessment, okay? The other conditions would be the standard things that you do when you're on probation, which are, tell them where you are, don't move without permission. They have to be able to get in touch with you. You report when you're told to, you take a drug test when you're told to, you don't break the law, you don't use illegal drugs or alcohol, that kind of thing, okay?
Yeah. Yes, sir.
All right. Is this what you thought you were agreeing to?
Yes, sir.
Do you believe that, as you heard me go through it, that I added anything to the agreement that wasn't already in there?
No, sir.
Do you believe I left anything important out?
No, sir.
All right. Do you believe that you have been promised anything or threatened by anyone with anything other than the Commonwealth's promises to make these recommendations to me?
No, sir.
All right. Ms. Nance, do you feel like I am making you enter an agreement?
No, sir.
Okay. Are you doing this voluntarily?
Yes, sir.
Are you acknowledging to me that on or about the second day of March 2019 in Barron County, Kentucky, you knowingly and unlawfully possessed an amount of methamphetamine greater than 2 grams with the intent to sell, distribute, dispense, or transfer it?
Yes, sir.
All right. Are you also acknowledging that at that same time and place, you were in possession of Suboxone, a Schedule III controlled substance, and that you were in possession of drug paraphernalia?
Yes, sir.
All righty, Ms. Nance, I'm going to accept your plea of guilty today. Now, you had mentioned, well, Mr. Berry, do you think that Ms. Nance wants to be sentenced today, waive a PSI and be sentenced today, or is that something that you want to try to do a PSI on?
I think she'd rather go ahead and be sentenced today.
Yes, sir.
Okay. Ms. Nance, I will tell you this. I do not know how many days of pre-sentence credit you're going to be entitled to. I do know that it looks like you got arrested on a bench warrant at least 2 months ago, right? So it was it back in December?
I got picked
Judge.
up on December 5th and brought
What-
in. I got picked up on December 5th and brought in.
Yeah. That's what I'm saying. We were talking about your credit that you're entitled to. And
Yes.
so you're entitled to those days, which is, 60 some,
Right.
right?
And the original rest date was like 8 days.
Yeah. And then I was going to say, I don't know how many days you were in there earlier, but you get those too. So, what I'm trying to tell you is I can't tell you what day you're going to
Okay.
get right now,
Okay.
but when we do your judgment, which will probably be in the next day or two, we'll calculate it all and it'll be in the judgment,
Okay. All right.
the number of days that you've been in there.
Okay. Thank you.
And there'll be there's typically a release date in there too, so that the jail doesn't have to guess what day you're going to get
Okay.
out, all that kind of stuff.
Okay.
Now-
Thank you.
You're welcome. I've got, do I still have Officer Bragg on here? Yeah, there he is. Officer Bragg, here's the deal with Miss Nance. She's going to be probated and she'll be getting out. It isn't going to be in the next few days, but it'll be, earlier than 2 months from now. So you all will get a copy of this whenever we do it, so you'll know also. But ask her what you need to ask her, please, and then tell her what you need to tell her, okay?
Great. Ms. Nance, do you have a phone number and an address I can have?
Yes. The address is, you want a mailing address or living address?
Physical address?
Physical, it's 305 Mackey Street, Edmonton.
Do you have is the mailing address a PO box?
Yeah. And it's PO Box 595.
Okay, what's the phone number?
270-432-5328.
Okay, and just whatever day you get out, you need to report to the office. They don't know when it's going to be, but just be there the same day you get out.
Okay. Yes, sir.
And yeah, the only exception is obviously if you get out on a Saturday or a Sunday, you just go that next Monday.
Okay.
Yeah. And are you, when you say your street, is it Mackey?
Yes.
Mackey?
Yes, sir.
All right. Just want to make sure. All right. So, Ms. Nance, I'll send it to you today based upon your plea of guilty and your waiver of a PSI to count 1, 5 years, count 2, 12 months concurrent, count 3, 12 months concurrent for a total of 5, forfeiture of cash seized. Your fine and your costs will be served out by your 120-day alternative sentence. Okay. So, you're going to get out and not have a bunch of extra stuff you have to worry about, except just getting right and staying right, and obeying your probation rules. Okay.
Yes, sir.
All right.
Thank you.
All right. Let's see. Larry York. Did I get
He's mine, Judge. You got an agreement on that.
all right, hold the phone here. Did I get some paperwork on? I think I printed it.
It should be.
No. I'm on Tracy Rock. And if that's the case, we need to get Ken on here because he ain't on here.
He's on, Judge.
Where is he?
I think he's the Zoom user.
Zoom.
Judge, I'm here.
Yeah.
I got you. All right. All right. Well, you can go back to being a Zoom user because I'm going to do Larry York real quick. Hello, Mr. York.
How you doing?
Yeah, I'm doing all right. Yourself?
Yeah, I'm doing all right.
Looks like what we got here is an agreement in your 20 CR 395 and then an agreement in your F case to waive presentation of of those charges to the grand jury and go ahead and enter a plea in that case too. Is that right?
Yeah.
All right. You ready to go with that?
Yeah.
Okay. Will you raise your right hand? Do you swear to tell me the truth, so help you God?
Yeah.
All right, thank you. Anytime we do this, there's a bunch of papers, so I'm just trying to get through it all here.
All
All right, so the first thing let's talk about is that you've got these motions to enter a guilty plea. And what appears to me is that I've got 2 front pages and no back pages. So we might have to track down the signature pages, but, and they may be in there, but I don't have them. So, but are you comfortable telling me that you went over these motions to enter a guilty plea and you did in fact sign them?
Yeah.
All right. Did you talk to your attorney about it while you were doing it?
Yeah.
All right. Did you have any questions that you didn't get the chance to ask?
I like to, yeah, I was wanting to see if there's any way, when he files for shock, if I might be able to get shocked out to like a long-term treatment. I know, I think he said that, Gardner was going to oppose any kind of probation or shock. I'd like to ask for some kind of long-term treatment if any way possible. If not, that's understandable too.
Yeah, I understand. Well, let's do this. Let's work through the plea of guilty part, and then we'll talk about the recommendations from the Commonwealth, and then we'll talk about probation and what might happen there too. Okay.
All right.
We'll get to it though. Don't worry. I'm not putting you off. But as far as that motion to enter a guilty plea, do you feel like you understood those documents when you signed them?
Yes, sir.
All right. Do you understand that you have the right not to incriminate yourself, which you waive if you plead guilty?
Yeah.
You have the right to a trial where the Commonwealth has to prove guilt beyond a reasonable doubt, and you waive that if you plead guilty?
Yep.
You understand that you waive the right to confront and cross-examine witnesses and to put evidence on in your own defense if you plead guilty?
Yeah.
And finally, Mr. York, do you understand that you waive the right to appeal if you plead guilty?
Yeah.
Okay. Today, as you stand here, do you feel like you are under the influence of anything that is impairing your judgment?
Nope.
Do you feel like your judgment is impaired or faulty for any other reason today?
Nope.
You having any trouble understanding me
No, sir.
or hearing me?
I'm understanding, hearing you good.
All right, fair enough. In this case, in these cases, we need to talk about them in separately. So the first one we'll discuss is 20 CR 395. You were charged in that case and indicted by a grand jury with the offenses of theft by unlawful taking 500 or more, a Class D felony. And on a guilty plea, the Commonwealth agrees to recommend a 3-year sentence. You were charged with driving under the influence, second offense. And on a guilty plea, the Commonwealth agrees to recommend a 6-month sentence, a fine of up to $500, a DUI service fee, DUI counseling, and a license suspension as provided by law. Under count 3, you're charged with driving on a suspended license. On a guilty plea, the Commonwealth agrees to recommend 90 days. Count 4, prescription not in the proper container. And on a guilty plea, the Commonwealth agrees to recommend 90 days. Count 5, PFO first degree. Commonwealth agrees to dismiss that on a plea to the other charges. The total recommended sentence would be a 3-year sentence, fine of up to $1,500, a DUI service fee, alcohol, substance abuse, DUI counseling, and a license suspension. The Commonwealth is going to oppose probation, and the sentence in this case would be consecutive to your F case that we haven't talked about yet, but we're getting ready to talk about. Do you understand all of those things?
Yes, sir.
All right. Now, other than the Commonwealth's promises to recommend those things to me, do you believe that anybody else has promised you anything that I have not talked about?
No.
Talked with you about? Okay. Has anybody threatened you to try to get you to plead guilty?
Nope.
Okay. Are you pleading guilty voluntarily?
Yes, sir.
All right. Mr. York, are you acknowledging to me here today that on September the 26th, 2020, in Barron County, you knowingly and unlawfully took or exercised control over a 1999 Ford Ranger and its contents belonging to another person valued at over $500, less than $10,000, with the intent to deprive the lawful owner thereof.
Yes, sir.
All right. Are you also acknowledging that you were operating a motor vehicle at that time and place while under the influence of a substance or combination of substances that impairs your ability to drive?
Yes, sir.
And that you have a prior DUI conviction in the last 10 years?
Yeah.
All right. So,
on those DUIs, I thought it only went back 5 years because I was just locked up for 60 months. I just done 60 months. That should have been my first DUI. It only goes back 5 years, ain't it?
they go back 10 now.
They go back 10?
Yeah. As of, I don't remember when that was, about 3 years ago.
Okay.
They were
Yeah.
just kidding when they told you it's 5 years.
Do what?
But they were just kidding when they said it was 5 years.
Yeah, that was just a fun and games. All right. Are you also acknowledging that at the time you were operating a motor vehicle, your license was suspended, canceled, or revoked?
Yeah.
All right. And last but not least, that you were in possession of a prescription that was not in the container in which it had, a prescription controlled substance that was not in the container in which it had been dispensed.
Yeah.
All right, Mr. York, I'm going to go ahead then and accept your guilty plea in that case. And then let's turn our attention to the Metcalf case. In that one, again, you signed a plea of guilty or motion to enter a plea of guilty in that case as well, right?
Yes, sir.
Yeah. And are you comfortable with the amount of time you had to look over that?
Yeah.
You feel like you understood it?
Yeah.
You had a single count in that case, and it's theft by unlawful taking, 500 or more. That is a Class D felony. The Commonwealth agrees to recommend a 3-year sentence. The 3 years in that case would be consecutive to the 3 years in the case we just talked about. And the Commonwealth opposes probation in this case like it did in the previous case. Is that your understanding of the offer?
Yes, sir.
Other than that, has anybody promised you anything or threatened you with anything?
No, sir.
All right. Mr. York, are you pleading guilty voluntarily in this case?
Yes, sir.
Are you acknowledging that on December 1st, 2020 in Metcalf County, Kentucky, you knowingly and unlawfully took or exercised control over movable property of Ace Hardware valued at $500 or more, but less than $10,000 with the intent to deprive the lawful owner thereof?
Yes, sir.
All right. Mr. York, I will accept your guilty plea in that case as well as in the other case. Are you going to ask me to go ahead and sentence you today?
Yeah. I'd like to get sentenced today, waive my PSI and all that. It's
All right,
possible.
good deal. Yeah. Okay. So here's what we're going to do. I told you that we would talk about what you brought up at the end. And here's what we're going to say about it. Right now, the Commonwealth is opposing probation. They indicated in their plea offer that they're going to oppose a request for shock probation in the future. That does not mean that nobody can tell you you can't ask for it, and nobody can tell you that it's going to, how it's going to get ruled on. Okay. They're just that if you do ask for it, they're going to say no. If you ask for it, and if you propose that you go to treatment, who knows, they might change their mind. Even if they don't, it's conceivable that you could still get shock probation. I do think probably treatment, if we did it, would be something you would have to do. Okay. So, but that'll just have to be something that we decide when and if you file that motion and see kind of how the chips fall at that time. Okay.
Okay.
All right. Do you have any questions?
No.
All right, Mr. York. Good luck. That takes care of us. Okay.
Okay.
All right.
Judge, we have those motions here. I don't know why I didn't scan both sides of those when we sent them, but we'll send those in too.
All right. Thank you. I'm not saying that you didn't do it. I'm just saying that either when I printed them or whatever happened, the signature pages didn't come out. It very easily could have been my fault, but I need them.
We'll send them. We'll send
All
them.
right.
Take full blame. I did not scan them.
Oh, well, thank you.
Are we done, Judge?
Yep.
Yeah, but see you.
All right. Thank you.
It's all Denise's fault.
I own it.
Just kidding.
All right, so let's get Mr. Wright.
Do you have the paperwork, Judge?
I do.
Okay.
I do. All right, so Mr. Wright, I've got some things here that include a motion to enter a plea of guilty and a written offer from the Commonwealth, okay?
Yes, sir.
All right, do you feel like you're ready to go on those?
Yes, sir.
You raise your right hand, please. Do you swear to tell me the truth, so help you God?
Sir.
All right. All right, first off, let me go over this motion with you. You recognize that?
Yes, sir.
Find me. All right. Is that your signature?
Yes, sir.
Okay. Did you read that before you signed it?
Oh, yes, sir.
Did you understand it?
Yes, sir.
Okay. Are you comfortable that you've had time to talk to your attorney?
Yes, sir.
All right, Mr. Wright, this is the Commonwealth's plea offer. And again, you see there, it's just got blue ink on it because I marked out the PFO language because I saw on here that they were going to ultimately the decision in the offer is that they're going to dismiss the PFO. So, and it's been signed. Is that your signature?
Yes, sir.
All right. Mr. Wright, did you read over that document before you signed it?
Yes, sir.
And did you understand it?
Yes, sir.
All right. Are you prepared to go forward with this plea of guilty today voluntarily and of your own free will?
Yes, sir.
You understand that you waive the right to remain silent and not incriminate yourself, the right to a trial by jury where the Commonwealth has to prove guilt beyond a reasonable doubt, the right to confront and cross-examine witnesses, the right to put evidence on in your own defense, and the right to appeal if you plead guilty.
Yes, sir.
Okay. Mr. Wright, do you feel like your judgment is impaired for any reason today?
No, sir.
All right. Do you feel like you're under the influence of anything today that has made it difficult for you to exercise your decision-making capacity?
No, sir.
All right. The Commonwealth agrees to make the following recommendations on a plea of guilty. Count 1, trafficking in a controlled substance, first degree, 2 or more grams, first offense. That's a Class C felony. On a guilty plea, the Commonwealth recommends a sentence of 6 years. Count 2, trafficking marijuana, under 8 ounces. That's a Class A misdemeanor. Commonwealth recommends 12 months. Count 3, possession of drug paraphernalia. Commonwealth recommends 12 months. Count 4, persistent felony offender. On the plea of guilty to the other 3 charges, the Commonwealth agrees to a dismissal of that charge. The total recommended sentence would be 6 years plus a possible fine of up to $1,000 and court costs, forfeiture of the items seized at the time of the arrest, and the Commonwealth opposes probation. If you have any other cases with time on them, this sentence is consecutive to those cases. Do you understand that that is the recommendation of the or the offer of the Commonwealth?
No, sir. I signed for a 2-year agreement in Hart County that was to be run concurrent with this case.
Well,
Judge, I think what he's talking about is Hart County may have made a condition of that plea that they would run theirs concurrent. But of course, whichever the court sentences last is the one who controls.
Well, what was the timing on the Hart County case? Did it happen after this one or before this one?
After this, Your Honor. It would be the day I was arrested and brought in on this is the day I caught the Hart County case. But when I signed it, I signed that plea agreement because it was to be ran concurrent with my pending Barron County charges.
Judge,
Yeah,
I
I
think if
understand.
it's,
Go ahead.
if it's in the order for Hart County to run theirs concurrent, then I think that probably would work.
Yeah, this offer says that it would be consecutive to any prior case. And that's why I was asking about the timing, because if that case is a case that occurred after this case occurred, I don't think it would, I think it would depend on the offense date, because you see what I'm saying? That
Yes.
if Hart County, which would have the discretion to run its case concurrent or consecutive, because he was on bond apparently when he picked that case up, if they decide to run it concurrent, then it's my understanding that the Department of Corrections will run them concurrent, as long as Hart County specifically says that in their judgment.
I agree.
Because this says
Hey,
consecutive
Judge,
prior cases, and that is not a prior case. That's a subsequent case.
Judge, I was going to say, I'm looking at his Hart County case. It looks like he was indicted September 2020. So I don't think that was ever a prior case. This case has been sitting here for a while. This is a 19 CR case, and then of course he
Right.
had it
Right.
earlier in 2019.
That case isn't going to qualify as a prior case. It's a subsequent case. So it wouldn't, the language in this plea offer that the time runs consecutive with any prior case is not going to apply to that case, because it's not a prior case. Okay?
Alrighty.
Does that make sense?
I guess, yeah, as long as they're running it concurrent, it's all I was worried about. Because I know that's the plea agreement I signed with Hart County. Whenever I signed their plea agreement.
Sure. And I mean, we can't change anything that's in your Hart County plea agreement. I mean, that's you know.
Right. Well, I just didn't want to go ahead and be like, yeah, I signed that. And now they're going to put 6 on
Yeah.
top of it too. But
Yeah.
Tracy, it's all good. It'll work out like you want.
okay, thank you.
All right.
In that case, yes, Your Honor.
Do what?
I said in that case, yes, Your Honor.
Oh, all right. Good deal. So, Mr. Wright, are you acknowledging that on October 19th, 2019, in Barron County, Kentucky, you, let's see, knowingly and unlawfully possessed 2 grams or more of methamphetamine with the intent to sell, distribute, dispense it, or transfer it?
Yes, sir.
All right. Are you also acknowledging that at that same time and place, you knowingly and unlawfully possessed an amount of marijuana less than 8 ounces with the intent to sell or transfer it?
Yes, sir.
All right. And also, are you acknowledging that at that same time and place, you used or possessed with the intent to use drug paraphernalia?
Yes, sir.
All right. Let me tell you all, Mr. Wright, I'll go ahead and accept your plea of guilty as having been entered freely, knowingly, intelligently, and voluntarily. Are you asking to waive a PSI and go ahead and get your sentence imposed today?
Yes, sir.
All right. That's fair. That's what we'll do. Now, I was going to say, if it's not, if everybody's intention and understanding is that this case, that the Hart County case is not a prior case, so that it's not intended that nobody intends for this to be consecutive to that one, probably the easiest way to keep any misfortune from befalling anybody would be for me to just identify that in the judgment and say that it's not, that this does not run consecutive to that Hart County 20 CR or whatever it is. Okay.
That's fine, Judge.
Because that way they won't worry about what we intended if we just come right out and say it. Okay.
All right. Thank you, Your Honor.
All right. So let's make sure we get that in there. All right. All right, Mr. Wright, I don't have anything else unless you have anything.
No, sir.
All right. Then we'll get this judgment entered and you're good to go. Okay.
So I will be final sentence now on this charge?
Yeah.
All right.
Yeah,
thank
I'll
you.
go ahead and impose that sentence today. Okay.
All right. Thanks, sir.
All right. Thank you.
Thank you, Judge.
Thank you.
else for us, Judge?
No, I believe that's it, Bonnie.
You all have a good afternoon.
All right, thanks.
See you tomorrow.
Let's see, I've got
Travis Wilson, Judge.
yeah, I think Travis, he's come in and out a couple times, so I don't know if he's still able to get in.
I'm here, sir.
You there? All right.
Yes, sir.
Judge,
Oh, go ahead.
I was going to say, evidently, I think Mr. Wilson was released from jail today. Greg and I were waiting to see. Hey, Greg, if I could just ask him real quick, Travis, have you completed your sentence?
Yes, sir. I served it out this morning.
Okay. Judge, I don't want to delay this too long. I was wanting to wait and see myself how to resolve this present case. If we can put this on in a couple of weeks, I'll send an offer to Greg to try to resolve it.
That'll work.
Greg, do you want me to, or does Travis need to give you his number, or are you giving him your number, or how, we need to make sure you all can meet up somehow?
Yeah, that's a good idea, Judge. Hey, Travis, you got something to write my number down with there?
Yes, sir.
Okay. It's 833.
Okay.
385.
Okay.
6055.
6055.
Right.
When do I need to call you, sir?
Probably about Friday.
Okay.
Did you want to do 3 weeks or 2 weeks? I forgot.
2 weeks.
All right.
And Greg, I'll get you an offer in the next couple of days.
Okay.
So Travis, we're going to put this off for, to February 22nd.
Yes, sir.
Get in touch with Mr. Barry before then, please. And it'll be back on, you'll be out of custody, we all hope. So you can just sign on the same way you did this time, okay?
Okay.
Let me
I'll
tell you.
see you.
Oh, go ahead.
I'll see you on my next court date on Zoom.
That's right. If we do it on February 22nd, we'll still be meeting on Zoom at that point.
Will it be February 22nd at 1?
Yes. Yeah. Well, we usually start at 1:30. We say 1 because we used to start at 1, but the jail is tied up at 1. So we really have been starting at 1:30.
Yeah, it took me a while to figure out how to log in, but I got it now.
Let me tell you this, if you all have an agreement that where you're going to be entering a plea, then I need for you to be somewhere, you know, where we can use your camera, because I need to be able to see you. Okay.
Okay.
All right. I mean, it's fine right now because
I'm trying to see.
If I'm going to take a plea from you, you know, I need to be able to eyeball you.
Got to get this camera.
You don't have to do it now, but I just need to be able to do it then. Okay.
Okay. But make sure it's. Thank you, sir.
All right. Be good.
Okay. Thank you.
All right. So this Fultz character, he is the one that you all said got picked up by Tennessee somehow. And I'm envisioning like a UFO picking up a cow, except the state of Tennessee picking up a guy. So I don't know what we're going to do with that. I'm open to questions.
I'll call up there. I'll call back up to Muhlenberg County late this week, early next week, and see because they thought he was already back, and the person I talked to had to go check, and they're like, no, he's still in Tennessee. But the weird part is he shows up on Vine, in Kentucky version of Vine, in Muhlenberg County jail in custody, and he shows up in Vine, Tennessee version in the Wilson County jail. I looked it up over lunch, and it's weird. He shows up in 2 different jails.
Well, the other interesting thing is he had a $5,000 cash bond in this case that he never posted, yet they still let him leave the jail and go to Tennessee. So that, they do things different in Muhlenberg County, I guess.
It's just like Warren County ignoring your bench warrants a while back.
Oh, yeah, well. Warren County's getting big enough to do what they want to do. Kind of like the Republic of Jefferson has always done.
I don't think any jail's quite got that bad yet.
Why don't I put Mr. Fultz over to March 1st, and then if he's not back in the Muhlenberg County Jail, you can have some kind of report for us.
Will do.
All right. I believe that's everything I've got on the docket, unless you all can think of something. Yeah, Brian Graves was in Kenton County, and Kenton County told KP that they weren't getting on a Zoom hearing. And then after further inquiry, she found out that apparently they just were going to be busy or something, and they said they could do it tomorrow. Well, so she told me she had moved it to tomorrow, but then I told her that I had gotten a text from Alan Shirley this morning, and he said he was going to go to Kenton County and pick up Brian Graves and bring him to the jail down here. So he might be in our jail by tomorrow. He might show up from Kenton County by tomorrow. I mean, I don't know what'll happen, but we'll revisit the issue tomorrow. I just wanted to tell everybody that's why we weren't doing it today. Okay? Okay.